So Dinesh, it was previously mentioned Section 5F. What does that part of the Act entail?
Yes, Section 5F relates to a marital relationship, a married relationship.
Is there a separate section for a de facto relationship?
There is a certain other provisions in relation to de facto relationship. Yeah, you are correct. And there are also Section 5 F2 in relation to this matter. I probably better read them. 5.2a says there are married to each other under a marriage that is valid for the purpose of this act. They have a mutual commitment to a shared life as husband and wife to the exclusion of all others. Craig, that is what was probably missing in the previous tribunal matter that we were discussing. And the relationship between them is genuine and continuing. And the last part, they must live together and do not live separately and apart on a permanent basis. So in that previous matter, Section 5F would not have been met.
How do you know, though, what genuine and continuing means to the department?
It's not specifically defined in the Act and the regulations. In that sense, it's a bit unclear. But we can get guidelines from the judgments, court cases, tribunal matters, and it's the ordinary dictionary English language meaning. Now, what's the meaning of genuine and continuing? And show evidence, not contrary information, but evidence to show that they have lived as husband and wife. If they continue to travel separately and travel from different locations, and if he is not nominated as the beneficiary of your super fund or in your will, if it's contradictory, if it's someone else, it's very difficult to come to a conclusion saying that it's a genuine relationship and not. Again, referring to that previous question and the facts of that matter, I think that may what have triggered the visa cancellation.
I want to go to the second part of our viewer's question, that the department says his evidence is not strong. By the department saying that to a visa applicant, is that suggesting that they're going to refuse the visa application, or is there an opportunity for this person to provide more information?
It is a possibility, but the department should, if they have concerns, put those concerns to the applicant under natural justice provisions.
So tell us a little bit more about natural justice.
Yes, natural justice is in a way an opportunity. If it is afforded, it must be afforded, gives an opportunity for the applicant to be heard. In fact, it's a right to be heard if there are accusations or allegations against, so they can either clear that accusations or clarify. And if the department does not do that, it can be considered as an error of law.
And then you would take it to the next stage, the tribunal?
May not be. The usual pattern is people do take it there, but I would argue if natural justice has not been provided, that itself is an error of law. So the department in fact has not made a decision to refuse the visa application because that decision was not based on law. So in fact they have not made a decision. We can go back and ask them to make a decision rather than going to the tribunal. But you need a lot of skills to understand that and put it across to the department, and department needs to accept that and remake the decision according to law. But I would argue...
Yeah, it seems like there's a lot of going back and forth and checking law and checking regulations. So would you suggest someone seek legal advice about all
I
these
would
things?
strongly in that situation. It's always our practice. I can't say anything else as a lawyer apart from saying yes, seek professional advice.
So Dinesh, in cases such as this, what is the ultimate test or the ultimate consideration that must be made?
Yes, in a spouse visa situation, the ultimate test or the substantial issue would be whether the relationship is genuine. In fact, the only true test as is that, as highlighted by the federal court, I'll read it out. The true test, we would suggest, the only test is whether at the time at which the matter has to be decided, remember, at the time at which the matter has to be decided, not even at the time of the application, it can be said that the parties have a mutual commitment to a shared life as husband and wife to the exclusion of all others. In this particular court case that I'm referring to, the department was excited, or the delegated member was excited about other matters which raised suspicion. So he asked the wrong questions, or maybe the correct question, but he did not ask the right question and consider the evidence to establish whether the relationship, despite the reason why they got into the marriage, for example, they might not have an intention to live as husband and wife at the time of the application. Remember, this is a time of decision criteria.
Two different times: time of application,
time of decision.
And time of decision is essentially when the court's making its decision. Yes.
Or the department must be making its decision. So at the time of decision, if it can be established, that's what needs to be established, that this is a genuine relationship, that what needs to be decided. If that question was not asked, in this question it was not asked, so that was an error of law.
We've discussed a number of migration matters today: passenger cards, spouse visas, and all the different considerations that must be made. All very thought-provoking, so I'd like to thank you for joining us today. In order to catch up on all our past episodes, you can go to our YouTube channel, just search Law Help Australia, and you can also go to our website www.lawhelpaustralia.org. If you have a question you'd like to submit, you can also email us at info@lawhelpaustralia.org. Thank you.